Supplementary list, item number 1 for pronouncement of judgment.
I'll read only the operative portion.
Please, Lordship.
Appellant is not here. Already run away. See, murder trials are very difficult to overturn, except there are circumstances which you cannot convince the court.
Absolutely, Lordship.
And sad to say, this is one of those cases. I'll read out the operative portion. Under the facts and circumstances of the case of the appellants herein, we find that this is a fit case for sustaining the finding of guilt by the learned trial court. However, we also find it fit to convert the conviction of the appellant from punishment under section 302 IPC to part 2 of section 304 IPC and sentenced to undergo rigorous imprisonment for a period of 5 years.
Lordship, I'm extremely grateful. I thought my learned friend would argue that part first.
No,
302, 304. But that was not argued.
That was a consideration by the court.
Well, absolutely.
The court has to do justice. See, that is what we have to do.
Yeah, absolutely, Lordship. We are very grateful. At least the court thought it, that there was an evidence that could have ordered.
With evil assistance from my brother, we are able to do it.
Lordship has dealt with it through conversion of this many times.
But it's a fit case. Sometimes murder is not so easy.
No, Lordship,
You have to
absolutely.
think. Not so easy.
No.
Unless it is premeditated or cold-blooded murder, they call it. Then you tell me, in your younger days, have you never encountered fist fight?
Absolutely, Lordship. And Lordship, when the judgment has passed, on hindsight, if you take Menger's scheme, that scheme part, Menger's scheme and this, a fit case for conversion comes out.
True, because
From 302 to only one argument.
it's an issue of angst.
And we are very grateful, Lordship. I'm much obliged.
Supplementary list, item number 1.
Actually, my colleague was here all along.
Your Lordship, may kindly put it at the end of the board.
It will never come, Your Lordship. There will be other
Your
issues.
Lordship, we have one more matter, Your Lordship.
Okay.
Kindly have.
Meantime, can I just let them come? I just continue with my reply on law points, Your Lordship, so that we don't waste the time of the court.
You have concluded your argument.
I have concluded with I made a submission that I'll make a reply on law points. So, meantime, there are precedents which I have to rely, Your Lordship.
But have they also, you have also advanced argument from your side?
Yes,
Never
sir.
advancing.
We have started, Your Lordship.
Started
There
with
was
the,
only some example discussion on some point whether 1937 rules will be override by that 3-bench decision, which is not correct. Lordship, point on that. Otherwise, they have concluded.
okay, so you continue. And your senior can come later. You can take down notes in the meantime.
See the judgment of my case. Lordship, before I come to some precedents,
Yes.
there are some law points that I want to highlight. Whether the rules for administration of justice 1937 is a special law. The rules for administration of justice 1937, Khasi Jaintia or Garo or even Nagaland are special laws, and as they designed to govern the tribal areas which were then under the British administration. They established a unique system distinct from the general legal framework applicable to other parts of India. They reflect a specific need and custom for the specific region. They are a special set of procedural rules notified for the administration of justice, and they constitute a self-contained court governing procedure before the courts in Khasi and Janda Hills. Rule 36A of 1937 rules is a special law. Hence, Section 5 of the Limitation Act 1963 is barred, more so in view of a specific bar under Section 29(2) of the said Act of 1963. Rule 36A of the Rules for the Administration of Justice and Police in Khasi and
What
Janda
does Section 29(2) says?
Limitation Act. I'll just
Please read on.
this is a saving clause, Your Lordship, under the Limitation Act 1963. I'll refer Your Lordship to subsection 2 of section 29. Where any special or local law prescribed for any suit, appeal, or application, a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period were the period prescribed by the schedule. And for the purpose of determining any period of limitation prescribed for any suit, appeal, or application by any special or local law, the provisions contained in section 4 to 24 inclusive shall apply only insofar and to the extent to which they are not expressly excluded by such special or local law. Just for a moment, Your Lordship, section 3 of the Limitation Act provides bar of limitation. Subject to the provisions contained in section 4 to 24 inclusive, every suit instituted, appeal, preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. That is what I am trying to say. That section 9 says, or section 29 says that subject to section 3, section 4 to section will not apply. 4 to 24 will not apply. Now I will continue, Your Lordship. Rule 36A of the 1937 rules is a special law. Hence, Section 5 of the Limitation Act 1963 is barred, more so in view of a specific bar under Section 29, subsection 2 of the said Act of 1963. Rule 36A of the Rules for the Administration of Justice and Police in Khasi and Janta Hills, 1937, does not incorporate or expressly permit the application of Section 5 of the Limitation Act, 1963. Nowhere in Rule 36A or elsewhere in the 1937 rules is there a provision empowering the appellate court to condone delay or import Section 5 of the said Act by default. So, in the substance of my submission is that, Your Lordship, the rules of 1937 is a special law. A special period is provided for filing appeal. Insofar revision is concerned, there is no period, but for appeal, 30 days is provided, Your Lordship. Now, the next point that I want to raise, Your Lordship, whether there is sufficient cause, even if we admit for the sake of argument that Section 5 of the Limitation Act is applicable, or
But can those merits be gone into or looked into by this court?
we are not going to merits, Your Lordship. I'm going to sufficient cause in filing the condemnation petition. Whether there was sufficient cause to condone the delay of 707 days.
But that is a finding of merits.
Pardon, Your Lordship?
That is a finding on merits.
I have challenged this court saying that there is no sufficient cause for condoning the delay, and that the lower appellate court has misread the rule of 1937 by saying that it is a state law, and after the coming of the state of Meghalaya, it is a state law enacted by the state of Meghalaya, which is wrong, and the Central Act, the Act of 1963, the Limitation Act, override the rule of 1937, which is an incorrect observation. Now, my point is that there was no sufficient cause. It is part of my revision petition, Your Lordship. Or whether court can condone delay of 707 days when the period of 30 days is self-contained in the rules of 1937. Sufficient cause is a legal threshold that demands real, credible, and satisfactory explanation. It must be shown with specific facts, diligence, and honesty, not general excuses, and also should constitute the following conditions. A party seeking condonation was prevented by fraud, natural calamity, court strife, or unavoidable illness. Delay due to incorrect but bona fide legal advice, limited acceptance, mistake of court in supplying documents, or costless. However, even these must be backed by proof, and delay must be reasonable, not excessive, especially in this present matter, 707 days. Further, the following must be fulfilled. Each day's delay must be explained. That's the law, Your Lordship. Condition must be backed by some evidence and diligence. Mere file movement, interdepartmental consultation, or law department advice is not sufficient cause under the ambit of the said provision. The sufficient cause accepted and admitted in para 30 of the impugned order by the learned lower court, which merely notes that the applicant had sought legal opinion or advice from many legal counsel, including the law department, is illusory and unsubstantiated. This observation does not constitute sufficient cause. I am making this submission, Your Lordship, that even if we are to accept that Section 5 of the Limitation Act is applicable, because in Section 5 of the Limitation Act says there must be sufficient cause, sufficient reasoning. That's why I am making this submission, Your Lordship. Seeking legal advice, opinion from multiple sources does not explain why it took 707 days to act. What advice was given and when? That is missing, Your Lordship. Why there was no urgency shown despite receiving adverse findings from the learned trial court? The state got a bad order, Your Lordship. My application under Order 7 Rule 11 was allowed, And when a state got a bad order, adverse order, it is for them to jump, Your Lordship, to file an appeal or whatever petition immediately, not wait for 707 days, Your Lordship. Major errors in the impugned order, Your Lordship. The Learned Lower Appellate Court in paragraph 24 and 25 of the impugned order dated 15/6/2023 opined that the rules of 1937 is a state law and Limitation Act is a central law, and hence erroneously applied Article 254 of the Constitution of India by waiving that a central law prevails over the state law, overlooking that stance of the petitioner, the special law are covered under Section 29, subsection 2. Unless expressly stated otherwise, the case of Shela Action Committee versus State of Meghalaya cited has no bearing on the applicability of Section 5 to Rule 36A, read with Rule 29 of the Limitation Act. There is no enabling provision under the 1937 rules for condoning delay. Thus, the appellate court lacked jurisdiction to entertain the delayed appeal. Holding sufficient cause established despite knowing the order, the applicant took nearly 2 years to act without any day-to-day explanation, as required in Ramlal versus Reva Coalfield, AIR 1962, Supreme Court, page 361. Consulting multiple legal counsel is not sufficient cause as admitted by the Learned Appellate Court at para 30 of the impugned order. I reiterate, Your Honor, consulting multiple legal counsels is not sufficient cause as admitted or as held by the Learned Appellate Court at para 30 of the impugned order. The justification that the matter was sent for advice to many legal counsel is not a valid ground. Delay due to bureaucratic red tape, multiple file movement or indecision cannot justify such a long delay, as held in Postmaster General versus Living Media, reported in 2012, Volume 3, SEC, page 563. Alternative remedy via writ appeal is not a bona fide diligence. The court accepted that the applicant initially pursued a writ appeal against a different order dated 17/2/2012 passed by the Honorable Single Judge, and only realized in 2018 that an appeal was required against the 2016 order of the Learned Lower Court. This confusion and procedural misadventure is not sufficient cause but gross negligence. Para 31 of the judgment states that the matter moved horizontally and vertically, which shows only file movement, not legal urgency or due diligence. This logic has been rejected in Maji San Nema versus Sridevi 2021 SEC, etc. Internal movement or consultation does not excuse delay. That the fact that non-mentioning a provision like Section 5 is not fatal, but here the very applicability of Section 5 is in dispute, not its citation. The state accepted the 2014 writ judgment and acted upon it by filing this money suit number 8 of 2014. Condoning delay reopens a concluded proceeding without any legal basis. The petitioners are prejudiced by revival of a suit long rejected on maintainability. Now, Your Lordship, I just want to bring to the knowledge of this Honorable Court that after the judgment passed by the assistant to DC, after the rejection of the suit, then the state went for appeal against the single judge order, filed a writ appeal. Now, in the meantime, when there was no appeal being preferred by the state, then we filed a money suit for recovery of the balance 2 crores, Your Lordship. And notices, everything was served, and prior to filing of the suit, Section 80 of the CPC was applied. Now that judgment, that decision in the money suit was decreed, Your Lordship. My colleagues say it was ex parte. It was not ex parte, Your Lordship, if we go into the records. We'll not go into deep into that. They had filed a petition for restoration. That also has been rejected and dismissed. Now, apart from what I have submitted, the state in 2012, after we have filed a writ petition, there are two writ petitions, they had filed a criminal case before the Director General of Police Meghalaya. Then the case was registered under the PC Act, under various sections of the IPC. Now, consequent to this case before the district session judge, Your Lordship, another case was launched against us. That is a case under the Enforcement Directorate, Your Lordship, Prevention of Money Laundering Act. The case went for so many years. Thereafter, it was both the cases after hearing, after 13 years, the case was closed and the accused persons, including me, were discharged. In the Enforcement Directorate case, which traveled up to Delhi, Your Lordship, there is an appellate tribunal, it was also dismissed and closed. It was first dismissed and closed by the learned session judge, PMLA. Thereafter, it traveled to Delhi and it was closed, Your Lordship. That's just a cursory information, Your Lordship. And I want to read the precedents, Your Lordship. My colleague is here. He may perhaps continue. I'll continue with the precedents, Your Lordship. Or if the court permits, Your Lordship, let my colleague finish whatever submission left. Then I'll continue with the precedents, Your Lordship. No.
Yes.
May I please? Lordship, on last occasion I submitted the history of the case, my lord. I'll just once again, my lord, refer to the process, how the land acquisition was started in this case, my lord. If Lordship kindly turns to page 63, my lord.
Lordship, my colleague is here. I just having giddiness. I'll just go outside.
Page 63.
63, my lord. I may also refer to the previous page, my lord.
This process started from 2011.
11, my lord. But in fact, page 62 also may be looked into, my lord. The previous page, my lord. This was on 2nd of March 2011, my lord. Now it says that this is section 4 notification. Section 4 read with 17E, my lord. It says, my lord, it is hereby notified that the land within the boundaries described below, measuring more or less 9 lakh so and so square meters in village Maupalai near Sumer in district Ribo is likely to be needed for public purpose for establishment of protected forest at Maupalai Ribo so and so, and the schedule is given, my lord. This notification is made under provision of section 4 of section so and so. So the land acquisition process started with this, my lord. Next page is declaration under section 6.
But the land acquisition process was not disputed.
Well, here what happened, my lord? There was some central scheme and forest department was required to, my lord.
The land acquisition process, as it is,
My lord.
in accordance with the provisions of the law.
No, there is no dispute in that. But the only dispute is about the ownership of the land itself. my
That comes at a later stage.
lord. Just immediately thereafter it came, my lord. I'll just take a lordship to.
But that came after the award was given to the.
Yes, my lord. 80% because this was emergency clause was invoked, my lord, under section 17A. So under that 80% of the compensation has to be paid upfront, my lord. So that this is what it says, my lord. The next page 63, lordship, if I may read. Whereas it appears that acquisition of land for establishment of protected forest of Mopalai River District is a matter of urgency in the interest of public service. In exercise of the powers conferred by Section 17(1) of the Land Acquisition Act as amended up to date, the Governor of Meghalaya is pleased to direct the Collector River District to take advance possession of the land fully described in notification number so and so, so and so, so and so under Section 6 of the Land Acquisition Act as amended up to date on payment of 80% of the estimated cost of acquisition to the persons entitled thereto unless prevented by something. So my next page 64, lordship will see.
64.
Page 64, my lord. The collector issued notice to Sri S.W. Rimbai, landowner. Notice is hereby given that in above case in which you have been treated as a person interested, an award was made by me on 9/6/11 and declared on 16/6/2011 under section 12 of the Act 1 of 1894. The sum payable to you is 8 crore rupees only. Therefore, you should appear before me personally on so and so date and collect the award, my lord. Next page is, my lord,
Yes.
handing over of the possession of land. Page 65. The certificate of taking over possession of the land, plot of land for establishment of protected forest at Mopalai near Sumer, so and so. So,
Just a moment.
my lord.
For my see, for my knowledge,
My lord.
whenever land acquisition proceeding is contemplated,
My lord.
the government sees or the whatever department requires any land,
My lord.
they will identify it.
My lord.
That process of of confirming ownership, title, everything, that is not you don't go through that. You simply issue the.
But they're supposed to go there, supposed to inquire who is the owner of land, my lord.
That's supposed to be done.
For any land, when large tract of land is acquired, my lord, it is duty of the collector or the revenue department of the district, my lord, to verify who is the owner.
Then they issue the notice under section 4 and the list of interested person are contained therein. But that is not done here.
That was apparently done, my lord, and it appears the district collector, the office of the collector came to finding that this land belongs to Mr. S.W. Rimbai, my lord. So he was called 80%. Now,
if you go to the genesis of the issue,
my lord.
You are at fault.
Yes, my lord, state is one, my lord, but here before lordship is forest department, my lord.
Whatever the case may be, whatever the case, it's always under the umbrella of the state. Collector is also, an official of the state.
But in my humble submission, we are past that stage, my lord, because various orders have been passed by this honorable court. So there was a mistake, my lord. That is why all this has cropped up now.
The issue of due diligence
has
not been looked into.
That's I admit that, my lord.
Please continue.
Now what happened, my lord? After he collected 8 crore rupees, my lord, I'll draw your attention to page 67, my lord.
This is
page 67, my lord. This is a letter from Soil and Water Conservation Department to Forest Department, my lord. This is dated 28th May 2012. Subject: establishment of Mopalai protected forest, number so and so. In inviting a reference to your letter cited above on the subject, I am directed to furnish below the requisite information as called for. Area of plantation 178 hectares. Date of creation and age of plantation. The plantation was created in different years starting from 1959 to 60 to 1972 to 73. Hence, the age of plantation ranges from 40 to 52 years. The current status of the land is still in possession of the Soil and Water Conservation Department. Date of handing over does not arise in view of so and so, so and so. So at this stage, it became evident, my lord, the land already belongs to state government, my lord. Plantation is raised by Soil and Water Conservation Department since before the creation of state of Meghalaya, my lord, and there is something wrong, my lord, in payment of compensation to a private party. Then, my lord, next page 68, lots of kindly see.
Yes.
Then Deputy Commissioner wrote a letter to them, my lord, to S.W. Rimbai, landowner, general power of attorney holder. This is dated 8th October 2012. Land acquisition proceedings in connection with Maupalai protected forest. With reference to the subject cited, it has been reported by the Forest Department that the plantation in Maupalai is still in the possession of Soil and Water Conservation Department and they are maintaining it for last 40 to 52 years. Therefore, the land acquisition proceedings for the said plantation has to be quashed and payment made to you amounting to rupees 8 crore needs to be recovered immediately. Therefore, you are requested to refund the above mentioned amount, failing which action may be taken as per Bengal Public Demand Recovery Act and so on and so on.
What is the provision for this?
Madam?
Where is the provision for this under the Land Acquisition Act? For quashing of the whole proceedings?
My lord, this is here. What has happened is even beyond the scope of Land Acquisition Act. Land Acquisition Act does not envisage, my lord, that there will be such kind of mistake.
That's what.
My lord. Land Acquisition Act deals with if there is a dispute between two private parties, my lord. So those situations are envisaged in the Act.
Section 30 would.
My lord. But this kind of situation that land which belongs to government will be reacquired, my lord, or compensation paid to some third party, private party. This kind of situation is not even envisaged in the Act, my lord.
But you see, when you have made an assertion,
My lord,
here, then you have to be backed by relevant provision of law under any other law for that matter, or at this point of time, this whole thing has gone somewhere. At this point of time, you should have taken the initiative to go by way of a civil suit for recovery.
Well, that's what exactly happened subsequently, my lord.
Subsequently,
My lord. So, my lord, this was a notice issued. Then they filed a writ petition before this honorable court, my lord. Page 72.
72.
72.
Oh yes.
This is an order passed by Justice Sen at that point of time, my lord. My lord, by this order, what this honorable court held, my lord, I'll just refer to the last para, para 8 at page 75.
Page 75.
75, the para 8, my lord.
Yes.
In this instant case, from the submissions of the learned counsel and from the annexures referred to above, it is clear that 80% compensation has already been paid and possession has already been taken over by the government considering the urgency. Therefore, section 48 does not apply in the instant case. It is also a fact that land acquisition is to be conducted by the collector and not by the deputy commissioner. Hence, I find that notice for annulment issued by the deputy commissioner Riboy, District Nongpo, dated 8/10/12, as well as dated 15/10/12 are not in conformity with the provisions of the Land Acquisition Act. Therefore, both the notices, letter at Annexure 12 and Annexure 13 respectively, are hereby set aside. However, since public money is involved and since the amount is not meager but quite a hefty sum, and now the government has realized that the land was acquired by fraudulent practice, in such a case the government must get a chance to redress the grievance. Though this court is not in a position under Land Acquisition Act to direct the petitioner claimants to repay back the advance 80% amount of the compensation received until and unless title of the parties are decided by way of evidence. In the above circumstances, I hereby observe that if the government is sure enough that the petitioner's claimant had taken payment of rupees 8 crore by fraudulent practice, then in that case they should file a recovery suit before the appropriate court, failing which the respondent is directed to pay the remaining compensation of rupees 2 crore as agreed upon by the parties at the time of acquisition within 4 months from the date of receipt of the judgment and order to the petitioner, along with 9% interest and thereafter 12% interest for each day. So, this honorable court directed us to file a civil suit, my lord, And if we didn't file a civil suit within 4 months, because the balance 20%, 2 crore rupees was pending, we have to pay that. So in compliance with this, my lord, immediately we went to file a civil suit. Lords will see that at next page, my lord.
Yes.
But we'll see page 77, suit for recovery of money amounting to rupees 8 crore rupees. Registered as money suit number 8 of 2014, my lord. Now, my lord, after this suit was filed, the respondents here in my lord, they filed an application under Order 7, Rule 11, my lord. That you lords will see at page 89, my lord.
Yes. For rejection of plaint.
For rejection of the plaint on the ground that there is no cause of action for filing the suit. And also the suit is barred by law, my lord. So these are the two pleas taken by them. And this application was allowed by the trial court, my lord. The lordship will see that order at page 102, my lord. This order dated 16/2/2016, my lord. Page 108 is operative part. I'll just read one last two paragraphs.
Yes.
The second last paragraph. Hence, in view of the above foregoing observations made by this court with regard to the absence of cause of action and non-joinder of necessary parties as provided in under the proviso to Order 1, Rule 9 of the CPC, this court is of the considered opinion that the instant suit is not maintainable in its present form for non-joinder of necessary parties as provided under the proviso to Order 1, Rule 9 of the CPC, for want of a cause of action and for being barred by law as provided in clause A and D under Order 7, Rule 11 of the CPC, which is reproduced here under, where it does not disclose a cause of action, where the suit appears from the statement in the plaint to be barred by any law. With the above observation, the application filed by the defendant under Order 7, Rule 11 of the CPC is allowed and the plaint is hereby rejected and the matter stands disposed of. So, my lord, the learned trial court on their application under Order 711 held that suit is not maintainable, is barred by law and rejected the plaint, my lord. In the meantime, what happened, my lord? We complied with the order of the Honorable Justice Sen, my lord, by filing a civil suit. But somehow, my lord, the department was advised by another counsel to file an appeal against the order of Justice Sen, my lord. My lord, that appeal, your lordship will find at page 111.
109.
109. It starts,
111.
my lord.
This appeal.
This is the memo appeal, my lord. And ultimately, this was disposed of by this order, my lord. I think your lordship also part of bench in that. I'll just place this order. Mr. Officer. May I read this entire order? This will throw a lot of light on the entire thing. Okay.
Page, where is next this order?
No, this order came subsequently, ma'am. This is not a part of the record, but lots of can take over this.
Yes.
It's not on record, no, this order. I'll read this order in entirety, please. This appeal is directed against a judgment and order of February 17, 2014, passed on a writ petition instituted in the year 2012. The appeal was filed after a colossal delay of 861 days, and it appears that the application for condemnation of delay was not pursued with due diligence, despite such application being filed in 2016. The relevant application under Section 5 of the limitation came to be allowed by an order dated November 24, 2021. It is necessary to notice the two material paragraphs of the relevant order. The primary ground made out is that the appellant acted on erroneous advice. However, a serious objection is put up by the respondent, including the ground that the appellant had already acted in terms of the order and thus cannot no longer prefer an appeal against thereagainst. Without prejudice to the respondent contention that the conduct of the appellant precludes the appellant from filing or proceeding with the appeal, in view of the sufficient cause on the delay in preferring the appeal is condoned, let the appeal appear for appropriate consideration of weekends. Courts are by and large reluctant to shut out a litigant on the ground of limitation, even though the state is not a favored litigant. When delay is cited on behalf of the government, courts frequently take a lenient view. In this case, the court was more than charitable in taking on board an appeal of the year 2016 against an order of year 2014 that was sought to be effectively assayed only towards the end of the year 2021. As will be evident from the order of November 24, 2021, the respondent seriously objected to the condonation of delay, but primarily on the ground that the order has worked itself out and that the appellant had acted in terms of the order. Since such ground of opposition was strictly speaking not pertaining to the cause cited for the delay in preferring the appeal, but had more to do with the right of the appellants to question the propriety of an order that the appellants may have already accepted or acted upon, the issue was left open to be urged in course of the appeal. It is necessary at this stage to indicate the case sought to be made out by the appellant. According to the appellant, the first of which is the state of Meghalaya, no less a parcel of land at Umshao Khwan village was absolutely owned by the state of Assam, and upon bifurcation of the state and the creation of Meghalaya in 1972, the ownership of such parcel of land passed on to the newly constituted state, and it was in the possession of the Soil and Conservation Department. For reasons that are unclear and in respect whereof no explanation is forthcoming, the state of Meghalaya through its forest department apparently proceeded to acquire the land that the appellants now claim was owned by the state. The acquisition proceedings were instituted under the Land Acquisition Act 1894. Section 17 of the Act was invoked on the ground of urgency, and the parties they acquire at the behest of the department requiring the land on the one hand and the prescribed landowners on the other hand, agreed that a compensation of rupees 10 crore would be just in respect of the acquisition. A sum of rupees 8 crore was promptly paid and the possession of land was apparently made over to the state. Again, it is not clear as to whether physical possession was actually made over to the state or the land being rather huge, only a letter of possession was made over as a token of physical possession being surrendered by the perceived landowners to the state. Para 6. At a time when further sum of rupees 2 crore remained outstanding, it apparently dawned on the state that though the forest department had prompted to the state to acquire the land, such land was indeed a government land under the possession of the Soil and Conservation Department of the state. Upon such realization, a letter dated October 8, 2012 came to be addressed by the Deputy Commissioner to River District to the respondent to the following effect. I have read that letter to refund 8 crore rupees. A reminder followed on October 15, 2012 to the effect that erstwhile landowners should appear before the Extradition Commissioner so that necessary steps may be taken to annul the land acquisition proceedings for the above. It may do well to notice that the initial letter alluded only to possession and not to ownership, though the case made out by the appellant is founded on the state having exclusive title to the land in question. The letters were challenged by way of WPC number 299 of 2012, culminating in the judgment and order under appeal being rendered on February 17, 2014. In the course of allowing the writ petition, the writ court referred to section 48 of the Act that permits the acquirer to withdraw the acquisition proceedings prior to possession of the land being taken over. The writ court observed that since the possession of the land has already been taken over under the acquisition proceeding, such provision could not be resorted to. The writ court also expressed the view that since the acquisition proceedings were conducted under the orders and at the behest of the collector, the letters issued by the Deputy Commissioner to annul such proceeds were without jurisdiction. However, since the court noticed that the case sought to be made out by the state was that the state had been induced to purchase its own land, the writ court gave the state the liberty to institute appropriate proceedings for recovery of the money. The court also required the outstanding amount of rupees 2 crore to be paid without reference to any action that could be instituted with the court and provided for interest of the delay in payment. But kindly, I'll just observe what. Please. Para 10. Pursuant to the order dated February 17, 2014, the state proceeded to institute a title suit number 8 of 2014 before a court at Nompo, primarily for recovery of the money paid to the respondents herein on the ground that the respondents had no title to the land that was subject matter of the acquisition proceeding. The plaint relating to such suit has since been rejected on the respondent's application under Order 7 Rule 11 of the CPC, and the relevant court, discovering that the plaintiff in such suit had no cause of action, particularly in the light of the acquisition proceedings not having been appropriately annulled. The appellants say that an appeal was preferred against the order of rejection of the plaint, but such appeal has since been dismissed for default. The appellants claim that an application has been filed for readmission of the appeal, but it does not appear that the matter has been prosecuted with any degree of diligence. But there's some factual error in this paragraph, my lord. I'll point that out. In 2016, the respondents instituted a title suit number 4 of 16. They instituted, my lord, before the same court at Nompo, seeking the balance payment of rupees 2 crore and interest due from the state in connection with the said acquisition. Such suits have been decreed on August 8, 2017, and it is admitted position that the decree for payment of the relevant amount remains unchallenged till date. In essence, it is a case of the state that either due to mistake or upon being induced by certain person, the forest department of the state proceeded to acquire a parcel of land that already belonged to the state, and in respect whereof the respondents herein had no title at all, and yet no meaningful steps have been taken by the state in such regard. It is elementary that in the course of acquisition proceedings under the Act of 1894, the title of the landowner is looked into and the compensation is paid only upon the relevant authority being satisfied as to the title of the payee. Indeed, disputes as to title and rival claims to the land sought to be acquired ought to be decided in the course of the acquisition proceedings as the scheme of Act of 1894 would indicate. Despite the obvious seriousness of the matter, it is also disconcerting that that the collector's authority was not invoked and the deputy commissioner issued an administrative letter in an attempt to undo the acquisition proceeding, which ought to be regarded as judicial or quasi-judicial in nature. It is further distressing that though the state seeks to paint a picture that it has been defrauded, the manner in which the matter has been conducted on behalf of the state leaves little doubt as to who may have failed or duped the state more than the respondents herein. Equally, it is conceivable that the Soil and Conservation Department was merely in possession of the land and the state may not have been the owner thereof, and the exercise launched by the state is for obvious extraneous consideration of its officials connected with the matter. It is quite possible that the state may have been the owner of the land and whether by inducement or by mistake proceeded to take steps to acquire its own property. There were legal avenues open to the state to undo the mistake committed, whether or not any fraud was perpetrated by any other in course of the acquisition proceedings. It is also not to be lost sight of that this is not an ordinary party which claims to have been defrauded. It is a state. If indeed the land was owned by the state and it purchased its own property with public money, all that was done was to issue 2 letters by the concerned deputy commissioner without taking any legal steps to annul the acquisition proceedings or undo what has been done. There is much more to the matter than meets the eye, and there is no doubt that a responsible state government will get to the bottom of the matter and book the culprits. As far as the present matter is concerned, it is evident that the appellants accepted the impugned order and acted in terms thereof, inter alia filing the suit for recovery of money. It is elementary that no litigant may approbate or reprobate in the same breath or in respect of the same cause. Indeed, upon the appellants having accepted the order and having instituted title suit number 8 of 2014 before the relevant court at Nompo, the appellants herein could not have been any longer to be person aggrieved by the relevant order to be entitled to prefer or pursue any appeal therefrom. In addition, the appellants herein have accepted the rejection of the plaint in their suit, or at any rate such a rejection has attained finality upon the appeal from the order of rejection of the plaint not being pursued by the appellant. That attempt at readmission of the appeal appears to be cosmetic. The further conduct of the appellants, as evident from the appellant not preparing an appeal from the decree of August 8, 2017, passed in respondent's money suit for recovery of the balance compensation pertaining to the acquisition proceedings, is a final nail in the coffin. It may also be noticed that no serious attempt was made in the writ petition to assert or establish the state's title to the land in question, whether or not the writ court may have been minded to enter into such disputed question. There is no doubt that the entire charade has been enacted with the deliberate intention of the state seeking to justify that it had tried to take action, but it was the court which went against the state. It is just as possible that the entire saga is a red herring. What must be realized at the end of the day is that the conduct of the state and the manner in which it pursued the matter has resulted in the adverse orders affected. There is also a lurking suspicion that the entire scheme has been designed with ulterior motive. For the reasons aforesaid, and since the appellants cannot be regarded as persons aggrieved by the order impugned upon having accepted the same and acted in accordance therewith, WA number so and so is dismissed, the cost assessed at 50,000 to pay to the respondent, and further sum of 50,000 to pay to the State Legal Service Authority within 8 weeks. So, my lord, the division bench, of course, there are some passing observations, my lord. In sum and substance, said that since you have already filed a suit, so the writ appeal will not be maintainable against the order of Justice Sen, my lord. Now, my lord,
So the title suit
my lord,
or the money, was it a title suit or money suit?
money suit, my lord.
Money suit filed by them.
They also filed a money suit for recovery of the 2 crore rupees, my
That
lord.
has been decreed.
That has been decreed, and
Execution.
that, my lord, I'll just draw lordship to page 144, my lord.
$144.
144. This is the decree, my lord. This was an ex parte decree dated 10th August 2017.
Ex parte degree.
This one ex
So
parte.
the trial has proceeded ex parte.
Yes, my lord.
It was shown to be proceeded ex parte, Your Lordship, but in fact the state were off and on appearing in lok adalats, etc., Your Lordship. In one particular instance, when there was a lok adalat, the particular officer even appeared and wrote a letter saying that this matter will not contest, something like that, Your Lordship, before the then Mr. Khan, Your Lordship, was a session judge.
Then, my lord, after that, after this ex parte decree was passed, my lord, state has filed an application for setting aside the ex parte decree that the lordship will see at page 145, my lord.
Yes.
Now, my lord, in the meantime, my lord, the department took legal advice from another counsel, my lord, and the other counsel advised the department that merely filing an appeal against the order of the London Single Judge, my lord, 2014 order will not suffice, because we must also, because there was no stay on that and will be time bound, my lord. So the government was advised to file an appeal against the order by which the suit has been rejected. Thereafter, my lord, page 154 is the application for continuation of delay in filing the appeal, my lord.
Yes.
So, my lord, page 154, lordship kindly see an application for continuation of delay of 707 days in preferring the instant appeal against the order dated 16/2/2016 passed by the learned assistant to deputy commissioner in Miss case number so and so, money suit number so and so. So this is the order by which the plaint was rejected, my lord. So we filed an appeal along with the application for continuation of delay, my lord, and they filed their reply, my lord, before the trial court. Lordship will see that at page 162.
Yes.
And the learned appellate court below, my lord, by order dated, that is it, annexure 1 at page 20, my lord, the impugned order.
Each.
Page 20, the beginning, my lord, first annexure. And by this order, the learned appellate court below has allowed the condonation in filing the appeal, my lord. Against that condonation of delay, they are before this honorable court challenging this order. Now, my lord, what I gathered from the submission and what was argued before the lower appellate court also, my lord, principally they have taken 3 grounds, my lord, of challenging the appeal. First, they've said that as a lordship has seen in the condonation application, we have not cited any provision of law, my lord. We've only said, my lord, at page 154, an application for condonation of delay of 707 days. So no provision has been cited, whether under Section 5 of the Limitation Act, so it has not been cited, my lord.
Okay.
So it is one of their ground, my lord, that no provision has been cited. So this application is misconceived or liable to be
But
rejected.
the impugn order has taken note of Section 5.
Yes, my lord. The impugn order, I'll take a lordship to that part, my lord. Secondly, they've said the ground they've raised, my lord, is that the appeal was filed under 36A, my lord, of the 1937 rules, my lord, and there is no provision for condonation of delay in the 1936A rules, my lord. That's the second ground they've taken. So these are technical grounds, my lord. On merit, they've taken a ground that no sufficient cause was made out by us for condoning the delay. So, my lord, I'll address these 3 issues which have been raised by them, my lord. My lord, how the learned trial court has dealt with the first issue, my lord, I'll take your lordship to the impugned order, para 18, my lord, at page 29.
Yes, please.
Page 29, my lord, para 18.
Yes.
Lordship has para 18. This court noted that the applicant has filed the application without citing any provision of law for condonation of delay, and the learned counsel for the respondent has raised objection that any litigant praying for condonation of delay must file such a petition, specifically mentioning the provisions of law under which the exercise of jurisdiction of any court is sought to be invoked. The learned counsel for the applicant submitted that the instant application has been filed under the provisions of Section 5 of the Limitation Act 1963, which is the only statute which provides for limitation and condonation of delay, and which is applicable to the entire state of Meghalaya as held by the Honorable High Court. Though Section 5 of the Limitation Act is not specifically mentioned in the cause title of the instant application, but non-mentioning of the provision of law is immaterial as long as this Honorable Court has the jurisdiction. In this regard, the reliance is placed on the Supreme Court decision in J. Kumaradasan Nair versus Eric Sohan 2009 so-and-so, wherein it has been held that it is also now a well-settled principle of law that mentioning of a wrong provision or non-mentioning of any provision of law would by itself be not sufficient to take away the jurisdiction of a court if it is otherwise vested in it in law. While exercising its power, the court will merely consider whether it has the source of exercise of such power or not. The court will not apply the beneficent provisions like Section 5 and 14 of the Limitation Act in a pedantic manner when the provisions are meant to apply and in fact found to be applicable to the facts and circumstances of the case. In our opinion, there is no reason as to why the court will refuse to apply the same only because a wrong provision has been mentioned. So, well, in my humble submission, the finding of the learned lower appellate court is based on the settled principle of law, my lord, and there is no
that it has jurisdiction.
As long as it has jurisdiction, my lord, whether the provision is mentioned, not mentioned, or wrongly mentioned, will not make any difference, my lord. The court can exercise the power. My lord,
Settled.
So, my lord, as far as the first issue is concerned, in my humble submission, there is no infirmity in the order, my lord, to exercise revisional jurisdiction to find any kind of defect in this order, in this at least finding on issue number 1, my lord. Now, the second issue that has been raised by them, my lord, I'll come to that now. Their contention is that, my lord, Section 36A has no provision for condonation of delay, my lord. But the provisions are quoted. I'll in this order itself. I'll read para 19, 20.
Yes.
Para 19. On the other hand, the main contention raised by the learned senior counsel for the respondent was that there has been no reasonable explanation by the applicant as to how and why it took more than a year for the appellant to file an appeal after 707 days. The application for continuous delay filed by the applicant is in respect of the application for appeal filed by the applicants under Rule 36A of the Administration of Justice and Police Rules 1937, which clearly stipulates a period of 1 month for the purpose of filing an appeal from an original decision of an assistant from the date of the decision, excluding the time period for obtaining a copy of the decision, and this court has no power to condone the delay in filing an appeal beyond the specifically mandated period within the framework of the rules, as well as the provision as to how to compute the said period. The applicant claimed to have filed an application under the provisions of Section 5 of the Limitation Act, which is only statute which provides for limitation and condonation of delay, and which is applicable to the entire state of Meghalaya as held by the Honorable High Court. And the question that arises for consideration before this court is as to whether Limitation Act has any application to appeal filed under statutory provisions of Rule 36A of the Administration of Justice and Police Rules 1937. Rule 36A of the Administration of Police Rules, Justice and Police Rules 1937 provides as follows. 36A, Appeal and Revision. The High Court or Deputy Commissioner may, on application or otherwise, call for the proceedings of any case decided by any officer subordinate to him and pass such orders as he may deem fit. The Deputy Commissioner shall be a court of appeal from a decision of the assistant. The High Court shall be a court of appeal from an original decision of the Deputy Commissioner if the value of the suit be Rs 500 or over, or if the suit involves a question of tribal rights or custom or of right to or possession of immovable property, provided that the petition for appeal accompanied by a copy of the order appealed against and by a clear statement of the grounds of appeal be filed within 30 days from the date of decision, excluding the time required for obtaining a copy of the decision. An appeal which lies to the High Court may be presented to the Deputy Commissioner. I can skip that part, my lord. Then it quotes Section 5 of the Limitation Act. Extension of prescribed period in certain cases. Any appeal or any application other than an application under any of the provisions of Order 21 of the CPC may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. It is observed that there can be no doubt that a special period of limitation has been prescribed for appeals under Rule 36A of the Administration of Justice and Police Rules 1937, whereby it provides that the petition of appeal accompanied by a copy of the order appealed against and by a clear statement of the grounds of appeal be filed within 30 days from the date of decision, excluding the time required for obtaining a copy of the decision. The question is whether the provision of Section 5 of the Limitation Act can be invoked in aid of the appellants for extending the time for filing the appeal under the aforesaid rule. This court has observed that Administration of Justice and Police in Khasi Jayantiya Rules 1937 was enacted by the state government and published by notification number so Meghalaya Act number 6 of 1972 with effect from 22 to 1972 and is applicable to the whole of the United Khasi Hills District and Jayantiya District, excluding the area which were known as the Khasi States before the commencement of the Constitution of India, for the trial of a particular case or particular cases, civil or criminal in a state. Therefore, it can be understood that the said rule is a state law. As provided by the Constitution of India under Article 254, if there is a conflict between the Central Act and the state law, the Central Act shall prevail, taking into consideration that the limitation is applicable in the entire state of Meghalaya, as held in the case of MC Review Petition number so and so Social Action Committee. Therefore, the application for condonation of delay filed by the applicant is deemed to be within Section 5 of the Limitation Act 1963. For exercising of discretionary powers to condone the delay, the court can entertain any application in the absence of formal application. Section 5 enables the court to admit an application of appeal if the applicant or the appellant, as the case may be, satisfies the court that he had sufficient cause for not making the application and or preferring the appeal within the time prescribed. There is no bar to exercise by the court of its discretion to condone the delay in the absence of a formal application as held by the Honorable Supreme Court in Sesnath Singh so and so. As such, this court has to look for the sufficiency of the cause of the inability of the applicant to approach the court within the time prescribed with the limitation. So only the second issue has been answered thus, my lord, saying on that Limitation Act is a central law, my lord, Central Act. The rules of 1937 are a state law, so central law will prevail in case of any conflict. Now, my lord, on this aspect, I'll take your lordship to the full bench decision for selection, which has been referred here also, my lord. Copies. The Lordship has a copy of this Cell Action Committee.
Yes.
Well, I'll take a Lordship to para 17. Well, the page numbers are para. The page number is there on top, page 24, internal page 24.
Yes.
Page number is written on top, very small letters near the QR code.
Yes. Yes.
At the bottom, question number 1.
Yes.
Page 24, internal page 24. Whether the provisions of the Limitation Act 1963 do not apply to the tribal areas now comprising the state of Meghalaya. This was the question, my lord. In comprehension of the scheme of the 6th schedule to the Constitution of India and the relevant provision of law with the principle expounded and explained by the Honorable Supreme Court, we have no hesitation in holding that the Limitation Act indeed applies to the entire state of Meghalaya, including the tribal areas. The line of argument suggesting inapplicability of the Limitation Act to the tribal areas of the state of Meghalaya has its foundation in the aforesaid notification dated 14/3/1966 as issued by the Governor of Assam, coupled with the provisions contained in Section 66 of the Reorganization Act of 1969 and Sections 77 and 79 of the Reorganization Act of 1971. And the support to this contention is taken from the decision of the Guwahati High Court in Minsong's case. The contention sans merit, and with respect, we find it difficult to accept the view taken by Guwahati High Court in William Minsong case as that of correct proposition of law. Indisputably, while framing the Constitution of India, a separate scheme was evolved for administration of several of the areas described as scheduled and tribal areas, and the 6th schedule to the Constitution of India in its original form made the provisions for administration of tribal areas in the state of Meghalaya, in the state of Assam. As noticed, the areas specified in Part A and B of the table appended to the original paragraph 20 of the 6th schedule were declared as tribal areas within the state of Assam. In the 6th schedule to the Constitution, in the beginning, it was provided that there shall be autonomous district councils or regional councils for the specified areas in the state of Assam, and such councils were vested with legislative authority on the specified subjects and were inter alia given the power to set up, administer their own system of justice and welfare services in respect of the subjects enumerated in paragraph 3 of the 6th schedule. As regards the applicability of the Act of Parliament and Legislature of the state of such autonomous districts and autonomous regions, overriding provisions were made in paragraph 12 of the 6th schedule, and by virtue of clause A of paragraph 12(1), no act of the state legislature in respect of any of the matters specified in para 3, for which the district council or a regional council could make laws, and no act of the state legislature prohibiting or restricting the consumption of any non-distilled alcoholic liquor were to apply to the autonomous district, autonomous regions, unless the jurisdictional district council would so direct by way of public notification with or without notification. However, clause B of paragraph 12(1) provided that the governor could by public notification direct that any act of parliament or of the state legislature of Assam to which provisions of paragraph 12(1) were not applicable would not apply to the autonomous district or an autonomous region in that state. The governor was also empowered to direct by way of public notification that such an act shall apply to such autonomous district or region or any part thereof subject to such exception or modification as specified by him in the notification. In the 6th schedule, transitional provisions were also made in paragraph 19 that as soon as possible after commencement of the constitution, the governor would take steps for constitution of a district council for each autonomous district, and until such constitution of district council, the administration of such district was to vest in the governor. Para 19 further provided that the Act of Parliament or state legislature would not apply to such autonomous district areas unless the governor by way of public notification would so direct and make it applicable with such exceptions or modification as may be specified. Significantly, the governor was also entrusted with the power to make regulation for the peace and good governance of any such area, and by such regulation the governor could have repealed or amended any act of parliament or of the state legislature or any existing law applicable to such areas. However, such regulations were subject to assent of the President. We have referred to the above mentioned originally enacted provisions in para 12, 20, 12 and 19 of the 6th schedule for the reason that these and some other provisions of the 6th schedule.
What is the purpose of this discourse?
But the discourse is, my lord, this Honorable Court referred to a notification of Governor of Assam, my lord. And the conclusion is that, my lord, the notification issued by Governor of Assam at that point of time, before creation of Meghalaya in 1966, will not apply after creation of Meghalaya, my lord. The tribal areas in Meghalaya, when they were part of Assam, my lord,
Even if it is adopted?
my lord, this is the conclusion, my lord. Because that notification has not been adopted, my lord. There is no order subsequently adopting that notification, my lord.
So it will have no power or no jurisdiction.
But I'll just refer to that specific paragraph, my lord, instead of reading the entire thing. My lord, the same very paragraph I was reading, my lord, we have referred to the above mentioned. Okay. What's the bottom, my lord, if lordship kindly sees?
The development of law.
6th line, relevant it is to notice. In the para starting, we have referred to the above mentioned originally enacted in the same para, my lord.
Yes.
5th or 6th line, it starts with relevant it is to notice. May I read from the only 2 sentences? I may read from beginning. We have referred to the above mentioned. What you has?
Yes, yes.
Above mentioned originally enacted provisions in para 20, 12 and 19 of the 6th schedule for the reason that these and some other provision of the 6th schedule have gone through a substantial transformation with the enactment of Reorganization Act of 1969 and Reorganization Act of 1971. And such changes are of direct bearing on the issue at hand. Relevant it is to notice that the said notification dated 14/3/1966 was issued much before promulgation of the Reorganization Act of 1969 and 1971 and was issued under the powers of the Governor of the State of Assam as were available to the as were available at the relevant time in para 12(1)(b) and 12(2) of the 6th schedule. The development of law after the aforesaid notification dated 14/3/66 had been that by the Constitution's 22nd Amendment Act 1969, Article 244A was inserted to the Constitution of India, enabling the Parliament to enact a law to give effect to the scheme for reorganization of Assam by forming within the state of Assam an autonomous state comprising wholly or in part of the tribal areas specified in Part A of table appended to para 20 of 6th schedule. This reorganization act scheme led to the enactment of Assam Reorganization Meghalaya Act 1969. As noticed from the appointed day therein, the autonomous state within the state of Assam was to be formed comprising the tribal areas of United Khasi Jaintihal district and the Garo Hills district. In section 66 of this Reorganization Act 1969, the provision were made that all law in force immediately before the appointed day would continue to be in force until altered, repealed or amended by a competent legislature or other competent authority. It was also provided that for the purpose of facilitating the application in relation to the autonomous state of any law made before the appointed day, the appropriate government could make adaptation or modification of laws within 2 years, whether by way of repeal or amendment as may be necessary. However, thereafter, full-fledged state of Meghalaya was formed under the Northeastern Areas Reorganization Act 1971, comprising autonomous state of Meghalaya formed under Section 3 of the Assam So-and-so Act. So much of the territory is comprised within the cantonment and municipality of Shillong, which did not form part of the autonomous state. By the same enactment, that is Northeastern Areas Reorganization Act 1971, the state of Manipur and Tripura were also established, and the unit territories of Mizoram and Arunachal Pradesh were also formed. Extensive provisions were made in this enactment for all such states and union territories, and extensive amendments were also made in the related provisions in the Constitution of India, including those in the 6th schedule. By the 8th schedule to the Reorganization Act of 1971, the above noted changes were made in para 12 and 20 of the 6th schedule to the Constitution. Among others, para 12A and 12B were also inserted by virtue of para 12A. Specific and distinct provisions were made as regards the application of the Act of the Parliament and Legislature of the State of Meghalaya by the Autonomous District and Autonomous Region, the State of Meghalaya. The question in the present reference relates to the Limitation Act, which is an Act of Parliament, and in that relation the relevant Clause B, para 12 could be reread as under: application of Acts of Parliament and the Legislature of the State of Meghalaya to autonomous districts and autonomous region in the State of Meghalaya. Notwithstanding anything in this Constitution, the President may, with respect to any Act of Parliament, by notification direct that it shall not apply to an autonomous district or an autonomous region in the State of Meghalaya, or shall apply to such district or region or any part thereof, subject to such exceptions or modification as he may specify in the notification, and any such direction may be given so as to have retrospective effect. In fact, similar provisions were made in the newly inserted para 12B as regards the application of the Act of Parliament to the autonomous district of or autonomous region in the United Territory of Mizoram. The sum and substance of these provisions as contained in para 12A and 12B is that in relation to the Act of Parliament, the President may by notification direct that it would not apply to the autonomous district or autonomous region, or would apply to such district or region or part thereof subject to the specific exceptions or modification, and such direction could be given retrospective effect too. Section 79 of the Reorganization Act provides that to facilitate the application of any law in the state of union territory formed under the provision of Part 2 of the enactment, the appropriate government may, before expiration of 2 years from the appointed day, make such adaptation or modification of the law as may be necessary or expedient. It is further provided that once such adaptation or modification is made, the law shall have effect to such application or modification until the same is altered or repealed by the competent legislation or competent authority. It is once clear that the notification dated 14/3/66 as issued by the Governor of Assam, whereby the Limitation Act was excluded from its operation in the tribal areas in the state of Assam, ceased to be applicable to such tribal areas that ceased to be the tribal areas of Assam and became part of tribal areas of the state of Meghalaya with effect from 21/1/1972. Well, this is the crux, my lord. What this honorable court held, my lord, the 66.
What was applicable in the in the state of then Assam would not be applicable.
Will not automatically apply. The President of India within 2 years,
unless there's a presidential promulgation,
my lord. And this, in fact, my lord, in the same para, there is a reference to Supreme Court decision, my lord, J. Thansiyama. Supreme Court said so, my lord, in respect of Mizoram, my lord. I'll just read the next para, my lord. The same position with its contextual variation has been declared by the Honorable Supreme Court in relation to the tribal areas forming part of the then Union Territory of Mizoram and now forming part of the state of Mizoram in J. Thansiyama's case after interpretation of the aforesaid provisions of the Reorganization Act of 1971. So this Honorable Court simply referred to Thansiyama's decision of Supreme Court. Only state was different, my lord. This is with regard to Meghalaya, that was Mizoram. And Supreme Court has very clearly said, my lord, that after creation of state of Mizoram, if there is no presidential proclamation, the Limitation Act will be ceased to operate, my lord. So, and that was the conclusion, and this is the conclusion upheld by this honorable court also, my lord. The earlier view in U Minsong case, my lord, by Guwahati High Court, my lord, has been overruled by a larger bench, referring to the Supreme Court decision. So the situation as it prevails now, my lord. I'll read the conclusion, my lord, page 33. Internal page 33, my lord, of the same judgment, my lord.
yes. Yes.
For what has been noticed and discussed herein above, we are clearly of the view that the Limitation Act, being an act of Parliament, and having not been excluded in its operation by any notification issued by the President, applies to the entire state of Meghalaya, including the tribal areas.
This order has not been challenged.
No, there's no dispute to this. I'm a party here also.
This is not
We are not in dispute that Limitation Act is applicable. Mizoram, Meghalaya. We are not in dispute. We are in District Council Court also. We are utilizing. We are everywhere.
So after this judgment, my lord, this part is settled, my lord. That
No,
limitation act is applicable to district council courts all across
everywhere.
Meghalaya.
We have no dispute with that.
And because there is a conflict,
So because of that, then the provision of it has not exactly overruled, but it has overshadowed the provision of section 36A.
No. That is a special law. Section 29 comes into play.
my lord, their plea was that under the 36 rules, my lord, there is no provision.
Yes.
Rule 41 says, my lord, if I just refer to rule 41. 41, no? 41 of the rules, my lord.
One is that 30 days period is given, isn't it?
30 days is given in 36
there?
itself, my lord.
Self-contained.
And 41 also is there, my lord, in the same rules. It says, my lord, application of Limitation Act. Although the Indian Limitation Act has been barred by notification number so and so, the principle of the act should be closely followed in dispute between persons not belonging to the Select tribes or tribes in respect of so and so. So, my lord, 41 also comes into picture, my lord. Here, one of the parties is not between both the parties, where both the parties are tribal, my lord. Here, state of Meghalaya is a non-tribal. So, Rule 41 itself says, my lord, in case of any dispute between where both the parties are not tribals, my lord, the spirit of Limitation Act should be closely followed. And that, moreover, the full bench decision of this honorable court, my lord, so the plea taken by them, my lord, the Limitation Act is not applicable, or there is no provision of for condoning the delay under the 37 rules, my lord.
Okay.
That also the full bench is held, my lord. This is a state law, 37 rules, and Limitation Act is a central law.
No,
So central law will prevail over
there's
this.
no holding that the rule of 37 is a state law. There's no such.
This was the last paragraph what I read, my lord, just now. Doesn't say in so many words, but it says, my lord, being an act of parliament.
Oh.
For what has been noticed and discussed, page 33, my lord. I just read page 33.
Yes.
For what has been discussed, for what has been noticed and discussed herein above, we are clearly of the view that Limitation Act being an act of parliament and having not been excluded in its operation by any notification issued by the President applies to the entire state of Meghalaya, including the tribal areas.
Okay. So, see, we are agreed that any act of parliament or central act will prevail over state
State law.
All right.
state law. Fine. Now, where is the the exception, where it says that central acts or act of parliament will not prevail as far as special acts are concerned operating within the state? Because what your contention is that this is a special act, its operation is within the state. So, as far as Limitation Act is concerned, being a central act, it will not have that overriding authority.
But here is a case of repugnancy, my lord.
Exactly.
Repugnancy, when a state law and a central law are in conflict, my lord, at any point it is so. Normally, central law will prevail, my lord. Then Constitution 254, I think, it says, my lord. But any state law can also prevail if the state law has received the assent of the President of India. Then it overrides even the central law, my lord.
Okay. So what about the rules then? The 1937 rules.
Well,
Have they received the assent of the President?
Governor in general, those days in council.
Governor in general, yes.
Those days.
It's a 1937 rule.
Governor
Pre-independence.
It's a
in general-
central law.
Yes, Governor in general.
It's a central law. That was prior in time before 1963. Limitation Act came into being in 1963.
Exactly.
And 1937 rules have not been repealed or anything. The Ratan Lal judgment, Ratan Singh judgment is there in this regard.
My lord, in my humble submission, after this full bench decision, my lord, it is settled position. Limitation Act is applicable, my lord.
No dispute.
No, that is, as Mr. Kanta said, maybe that's no dispute. Now we are coming to specifics. Whether it will have any overriding jurisdiction over special acts or not. And special acts having, received the assent of the, in this case, say Governor General or whatever, equivalent to President at that point of time. Whether, you have some, some materials on this.
Well, to answer that question, my lord, if you lordship kindly, if your lordship has the rule 41, my lord, 1937 rules.
It's been repealed by this. This is here. What is this? What is this?
Scan. Okay, kindly come to rule 41, my lord.
Yeah.
Well, the wording is like this, my lord. Application of the Limitation Act.
Yes.
Although the Indian Limitation Act 1908 has been barred by notification number so and so, so and so, so and so.
Principles of the act should be followed.
That's why rule 41. It only says, my lord, although the Indian Limitation Act has been barred by notification number 586 at AP dated 8 September 1934.
Yes.
This rule doesn't say, my lord, anywhere that Indian Limitation Act is not applicable in Meghalaya. If that was the situation, my lord, this thing would be different. The wording is, my lord, Indian Limitation Act is barred because of notification number so and so.
Yes.
Now this notification, my lord,
1934.
1934 notification has been repealed, my lord. I'll just place this. It says that no.
1934. 586 APB. Extent of repeal so far as the authorized law.
Now, my lord, kindly note one thing, my lord. This notification is of 1934. At that point of time, Limitation Act of 1908 was applicable in India, my lord. This Limitation Act came in 1963, my lord.
1963 would has repealed this 108, 1908.
No, my lord. But the notification of 1934 repeals says that Indian Limitation Act of 1908 will not apply. Now, once 1908 Limitation Act is repealed by 1963 Act, my lord, new Act has come. After 1963 Act,
So the
Governor issued 1966 notification, my
The
lord.
purport of the 1934 notification has lost its significance.
Lost its significance, my lord. Then 1963 Act came, my lord, Limitation
There
Act.
is no corresponding.
Then Governor again issued a notification of 1966, my lord,
Okay.
and that has been interpreted in Selection Committee decision that was by Governor of Assam for tribal areas within the state of Assam. Once Meghalaya is out, that notification will not apply to, and President has not issued any subsequent notification after that, my lord. So this is how it 1908 Limitation Act, 1934 notification, 63 New Limitation Act, 66 new notification, my lord.
Even so,
Well.
let's, as you see, even Mr. Kanta has agreed that the Limitation Act is applicable.
Well.
But in the context of these rules, then you have to again refer to this Rule 41,
Well.
which says that even though Limitation Act may be applicable, but the principle has to be
Well.
taken into account.
Well.
Because here it talks about principles.
Well.
course, that is in relation to the 1937 notification.
Right.
But if that is the case, then this rule should have been amended.
Should have been amended, it's not been amended. Because this is still reference of 1934.
Yes.
First amendment should have been made in 1966. That has not been done, my lord. And now, after selection committee decision, even that has not been incorporated in the rules.
If it is not amended, then it stays. It still remains in force. Now
34, because 34
there may have been a situation where there's a conflict now.
In my humble submission, my lord, once the 1908 Act itself is repealed, my lord, by Parliament, any notification touching on that or implementing or excluding that, my lord, loses its significance, my lord, the moment it was repealed.
You have a point there. So if we focus on Rule 41, read with Rule 36.
And a special law and general law, again, like I'll submit, my lord, that what a 36A rule says, appeal can be filed within 30 days. It doesn't say that it cannot be filed beyond that. Nor it says that it can be filed with application for continuation of delay. It doesn't say anything, my lord. So there is a vacuum in that. Now, my lord, that's where, in case of vacuum, the Indian Limitation Act will come and occupy that space, my lord.
That has to be explained by the General Clauses Act. No?
Because what will happen, my lord, in every case, even in criminal appeal, my lord, your lordship will find that appeal against the order of conviction has to be filed within 90 days or 120 days. Customs Act also.
Yes,
Then if it is not filed, then Limitation Act, it is not necessary for the same very act to say that Limitation Act is applicable or is not applicable, my lord. So the Limitation Act, being a general law, will come into picture.
That is the natural assumption.
My lord. So in my humble submission, 36A rules only prescribes 30 days. It doesn't say no more appeal after that. Doesn't say yes appeal after that also, along with the application for continuation. So this creates a situation of vacuum, my lord, and that's where Section 5 of the Limitation Act will come into picture.
On that proposition, you have some authorities then.
I'll try to get some, my lord.
I'll make my submission, Your Lordship. Precedents.
No,
Judgments.
Let him finish.
This query I'll answer. I thought the selection committee will cover that, but if the query has been raised, I'll try to answer this query also. So, 3.1.2, third issue is whether sufficient cause has been bear out by us for filing the appeal or not. For this, I'll have to take my lord to our pleadings in this case, my lord.
Of course, sufficient cause has to be from the pleadings.
My lord. So I'll take a lot today or?
No, I think we'll have to.
At the time for a division bench. You can continue any date.
Tuesday, Your Lordship. Tuesday. Since we are fresh in our mind, so Tuesday.
Wednesday.
Wednesday there will be
is a division.
There will be division bench.
No, but I think we have very less cases that day. I mean,
My matter also is there. It will take a long time on Wednesday.
Okay, Tuesday.
Tuesday, Your Lordship. Tuesday,
See, this is interesting point.
Yes.
Now we have entered into the realm of interpretation of statutes.
Yes, Lordship. If you have to accept my colleague's submission, then all laws passed by District Council in Meghalaya will have to be finished, because Election Tribunal says within 30 days you have to file the election petition. Then there are other laws also. 1953 rules also provide limitation of 60 days.
That is why I see, Mr. Kanta, when I've requested Dr. Mozika to come with authorities and president on that, he will come. You come with counter authority.
Yes,
and president.
And let us, because these are These are two laws on civil procedure. 1936A is also CPC, my lord, of Meghalaya. And limitation is also a part of CPC only, my lord. The CPC and limitation are taught together, my lord. So when procedural laws are in conflict, now so some other election law is in conflict, my lord, thing would be.
You see, then what happened is, you see, then we have to go into the exercise of going into the aims and objectives.
My lord. My lord.
You know, the statement made, all those things have to be, the preamble, all those things have to be gone to.
We're entering into a very, very
Like deep
crucial
discussion.
territory. I'll try to do this as well.
Heard Mr. G.K. Kenta, senior counsel for the petitioner.
I can do it.
Also heard Mr. Dr. N. Musica, you are special counsel.
Yes, ma'am.
Direct special counsel. As, direct senior counsel and special counsel for the state respondent. Hearing is not concluded and will continue on the next date fix as agreed to by the parties. This is matter 12.
Much obliged. Good day, Your Lordship.
Obliged.
Daily list, item number 1.
Nobody is there.
No, the petitioner counsel is not available today.
None appears with petitioner. This is matter on 13.
Item number 2.
So, Mr. General,
My lord, my
you
friend
had
has,
a refresher course just now. So,
my lord, my friend on the last occasion, on the last effective occasion, had, I believe, finished his submissions. I just have 3 very quick responses, my lord.
we have time?
I will not take much time. I have 3 responses, not more than 10 minutes, hopefully, my lord. Because extensive submissions were advanced, but to respond to each and every of those submissions, my lord, may not be fair on this honorable court. Too much time will be taken. So 3 important aspects, or at least what I thought were important, I'll respond to that, my lord. My lord, the first quick response.
yes.
The first quick response, my lord, is regarding a question that fell from my lord during the course of respondent submissions. In fact, it fell about 2 or 3 times. Lordship had queried very specifically whether the 1923 lease deed, of which I am a party, has superseded the 1914 lease deed, which they had entered into earlier with some other entity called Shillong Sports Club. The answer given by the respondents was yes, that 1923 has superseded 1914. In other words, according to the respondent, they are part of the same transaction. They are more or less the same lease deed. 1914, one lease deed was entered into, according to them, with us. In that lease deed, 16 acres was given to the other party by them. In 1923, another lease deed was entered into by them with us this time, clearly with us, and 10.19 acres was given in the 1923 lease deed. So according to them, this shows that 6 acres was returned to them in 1923, my lord. So the question whether 1923 has superseded 1914 is important. If the answer is yes, then the complexion of the game changes, my lord. But the answer is no, my lord. These are 2 separate lease deeds entered into by the respondents with 2 separate entities. If I can explain that part very quickly, if lordship,
But it refers to the same part and parcel of land.
no, my lord, that also no. I'll just explain. I'll just take 2-3 minutes to explain. If lordship kindly firstly looks at page 42A of the memo of appeal, the paper book, my lord. 42A, my lord, is the typed copy of the 1914 lease deed.
Yes.
1914 lease deed. Just below the schedule, my lord.
Yes.
Does hereby lease in perpetuity the said land covering an area of 16.91 acres, more or less, for a term of 10 years from 1st April 1914 to 31st March 1924. I will request Lordship to kindly notice 31st March 1924. So this 1914 lease was to be till 31st March 1924 to the Secretary Shillong Sports Club. The lessee's entity, the lessee's identity is also important, Shillong Sports Club. So 31st March 1924 is the expiry of 1914 lease deed. Now Lordship may kindly look at my lease deed, which is at page 16.
Are we decided on this first as far as the the nomenclature is concerned, whether it's the Shillong Sports Club or
I'll
Shillong
just
Club?
address that, because the finding of the first suit court is that Shillong Club, that is appellant today, is different, is not connected with Shillong Sports Club. That Shillong Sports Club is some other entity.
Yes.
That there is a clear finding, not challenged till today by the respondents. So I'll just address that also very quickly. But if I'm allowed to point Lordship towards page 16.
Page
16, my lord. Page 16 is my lease deed, that is 1923 lease deed.
Yes.
It refers to, my lord, if Lordship looks at the second last portion, second last line, the previous lease which is current till the 31st March 1922. So quickly refresh, my lord, 1914 lease deed, their lease deed with some other person, spoke of the expiry of that lease deed being 1924.
24.
This my lease deed speaks of some other lease deed which was to expire in 1922, clearly showing a 1914 lease deed has not superseded. There is no connection between these two lease deeds, my lord. With respect, my lord, the casual reply given in this for this contradiction is there was some typing mistake out here. It should have been 1924. My lord, something as important as this cannot be wished away by
You see, Mr. General.
my lord.
Then we have to look at the schedule.
My lord, I'll just come to the schedule also. In my next reply, I'll just come to the schedule. The schedule is also very instructive as far as their claim is concerned. I'll address that, my lord. I'll address that. But my first request to this honorable court is to kindly appreciate and kindly keep in mind that the two lease deeds have no connection with each other. Very clearly on the face of it, these are two different lease deeds entered into by the respondent with two different entities, my lord. Number one. Number two, my lord, the second response of mine was regarding the 6 acres, and this is where we come to the schedule, my lord. Lordship's query, one of the queries that fell from my lord was, where is the 6 acres located which they claim was returned to them?
General,
Yes.
I'm very sorry, but I think we are hurried for time.
Okay. We'll continue next week.
We'll take it up on 13th,
My lord.
on Wednesday, next Wednesday.
Wednesday. Very good. Very good. That is Thursday, my
I
lord.
think the board is slightly, free on that day.
My lord, that is 13th or 14th, because Wednesday is 13th, my lord.
13.
13th. Very good. Very good.
Wednesday, man.
Yeah, Wednesday. Yeah, 13. Labun. Huh? 13, 14 of, yeah.
Please, Your Lordship. Lordship, there's only one matter is pending. There's only one hearing matter. I'm praying it can come after a week, Lordship. Item 3, Lordship.
Okay. Heard Mr. Jindal, Legal Counsel for the appellant. Hearing will continue on the next date fix. It's agreed to by the parties. This is matter on for further hearing on 13. on plea made by Mr. Direct Counsel for the petitioner. Let us adjourn. List the same after 1 week.
I'll leave it.